thank you so much for taking time this evening to join us on what I think is going to be a fantastic discussion on due process issues on college campuses. And we're going to assume that most of you are familiar with the basic tenets of due process, what that means, and mostly what that means on campus as well. I know that in the past we covered due process, particularly as it pertained to sexual assault issues and the whole kangaroo court system that many college campuses had adopted, but due process is so much more than that, particularly in a day and age where cancel culture is a scourge and rampant everywhere. And so I am thrilled with our panel this evening. But before we get there, I have a couple of really boring disclaimers, but they are necessary. So first and foremost, this event is sponsored by the Legal Insurrection Foundation, and any of the views or discussion or opinions expressed here do not express the opinions of the Legal Insurrection blog or the Legal Insurrection Foundation. And secondly, this is not meant to be legal advice in any way, shape, or form. If you or someone you know finds yourself on the other end of this, please reach out to legal counsel. There are many people who are readily available to help you if you are being persecuted and being denied due process or believe that is the case. We are not those people. So please do not misconstrue anything that you hear tonight as legal advice. It is not, it is purely discussion. And I'm Kaye. I'm the Director of Operations and Editorial Development with the Legal Insurrection Foundation, where I have worked since we launched last March. I've also worked with Professor Jacobson at Legal Insurrection on the blog since 2014, the summer of 2014. So I've been working with them for quite a while now. And I work as a senior contributing editor there. We cover news of the day, various and sundry topics. We opine on the current state of politics, legal analysis. We do a lot of exclusive research, just a lot of really good content that we publish there every day. This event is sponsored by the Legal Insurrection Foundation, and we are donor supported. We run a very, very lean operation. We run a virtual office, and we don't spend any money that we don't have to. And all of our money goes right back into programming like this because we love to be able to provide good content and make events available to you for free. So if you are interested in donating, you can find all of that information on our site. But without further ado, I'm going to go ahead and introduce Professor Jacobson, who is the president of the Legal Insurrection Foundation and is also the publisher of the Legal Insurrection blog. So he's going to start. Then after that, we will have Professor Casey Johnson, who is of the Duke lacrosse fame. I mean, he's done some just incredible investigative work in following this issue and these cases for years and is truly an unsung hero on this issue. And Professor Johnson is a professor of history at Brooklyn College and the CUNY Graduate Center. His blog, Durham in Wonderland, explored the myriad legal, academic, and media scandals associated with the Duke lacrosse case, about which he also co-authored a book with Stuart Taylor. And Professor Johnson also co-authored with Taylor a 2017 book on the Title IX policy, and with Samantha Harris, who's our other panelist, a 2019 law review article on Title IX litigation patterns. And Samantha Harris, who is with us as well, is a senior fellow at the Foundation for the Individual Rights in Education and is of counsel at the firm of Mudrick and Zucker, where she concentrates her practice in the areas of campus discipline, Title IX, and free speech. For more than 15 years, she's advised students, faculty, administrators, and attorneys on issues of free speech and due process on campus. She lectures regularly about students' rights on campuses and conferences around the country, including the judicial conferences and the Third and Fourth Circuits. Ms. Harris has been published in Inside Higher Ed, the New York Daily News, Reason, the Washington Post, Vox, and many other publications, and has also represented FIRE on ESPN, Fox News, NPR, and many more. She received her undergraduate degree in politics from Princeton in 1999 and went on to earn her JD from the University of Pennsylvania Law School in 2002 and completed a judicial clerkship with the late Judge J.C. Waldman of the U.S. District Court for the Eastern District of Pennsylvania. So we have some fantastic panelists this evening, and we really hope you enjoy the discussion. You will find a chat and a Q&A box. If you have any questions throughout the discussion and conversation, please put them in the Q&A box, and I will be monitoring that as we go. The program will last as long as it takes to get through the content that our panelists have prepared for you this evening, and then we'll start taking questions directly from you. So again, if you have any questions, suggestions, comments, questions, put them in Q&A. Anything else, please feel free to put in chat. And so with that, I'm going to turn it over to Professor Jacobson. Thank you.
One, I wanted to thank Kemberlee for putting this together. She's put together several of our programs that we've done on various topics. And I think it's really, we've made lemonade out of lemons with the pandemic and not being able to do things in person. So I think this online is something we're going to continue to do even once we get closer back to normal. It's also great to be on a panel with Kaye and Samantha because they're two people I've admired greatly for the work that they do. And as great as Kemberlee's introduction was, it really is hard to do these two full justice. I mean, Kaye, I've known about since the Duke lacrosse case, but of course he's done so much more. And he was something of a blog god to those of us who had blogs and wanted to make a difference on our little platforms, and he made a difference there and has continued to. So I'm really appreciative that I'm able to be on a panel with him. And Samantha, I'm seeing her name everywhere. She is like the frontline soldier, the infantry who comes in to help people. And, I don't know her that well, but I'm actually beginning to know her a lot better because she's representing somebody, a professor down at University of Central Florida, who we as the foundation, together with Judicial Watch, are beginning to investigate that situation, and we've served a Florida records request. So it's really great to have these two on our panel, and they're going to be doing most of the speaking. So this is not our normal panel where you hear me drone on and on and on. I'm just going to have a very short introduction because Kaye and Samantha know a lot more about this subject than I do. When we speak about due process on campus, we're really not talking about abstract procedures in my mind, so I'm approaching this as somebody who's more of an observer. We're talking about people. We're talking about people accused of doing very serious things and who could have their lives upended or significantly ruin their careers based on the results. So this is about people, these people who've been accused, and also people who feel that they've been victimized. There are two parties here. But the premise that I start from is that there's no societal interest in convicting innocent people of anything, whether it's crimes or whether it's campus tribunals, whether it's alleged sexual assault, whether it's some sort of harassment. There's no societal interest in convicting innocent people. And the question is, how can we get to a process on campus where we're actually determining, if that's what the campus is going to do, guilt or innocence in a fair way that comports with what we understand the process people are owed. The other thing that I've observed is that that measure of due process and fairness does not seem to matter very much to many, if not most, administrations. They measure their success based on convictions, based on how many people are, usually young men, college-age men, are found guilty. That seems to be the statistics that matters. And I think the reason is that a lot of what is going on in this field is very ideological. It really is. And that's expressed itself in the vigor and viciousness with which the universities fight these things. I know Casey is going to talk about it, but there's one case we have followed, I should say, on the Legal Insurrection website involving our friends at Oberlin College, what we call John Doe number 1. We're now also on to John Doe number 2. But in John Doe number 1, there really is no disagreement among anybody that the result of the campus adjudication was probably wrong. Yet Oberlin is fighting up into the appellate process and probably will fight for years to uphold that presumptively wrongful conviction of the student. And Oberlin College, during the time period in question, had a 100% conviction rate for anyone who went to hearing, which was almost exclusively men. But it's not just Oberlin. There are many other cases. Casey and maybe Samantha will talk about those. And you've seen them in the papers and you've seen them on TV from time to time. Kangaroo courts is a phrase that's often used, but I'm not sure it really does justice to what is essentially the star chamber into which mostly young men are thrown as a result of accusations made against them. And I think we need to consider, why are campuses adjudicating these cases at all? And shouldn't the police be involved if there's an alleged crime that took place? Wrapping up my little section, I think this is something that everybody needs to care about. These, again, are people. These are your sons at risk. These where encounters which everyone at the time agreed was consensual, weeks or months later are changed into an accusation. And maybe there's good reason for that, maybe there's not, but we want that adjudicated in a fair manner. And beyond that, we also see it, it's one of the many manifestations of the politicized culture on campuses that has now moved into the broader campus as well. I think Samantha will probably address this. There have been new regulations that have been passed by the Trump administration and Betsy DeVos, and that, I think, over time will make a very significant difference, but who knows how long they will last depending on the outcome of the education. So my big takeaway is that this matters. These are people's lives involved. And now I'm going to turn it over to KC so he can talk about some of the case developments that have happened in the last year or so.
Thanks, Bill, for the kind words. Kimberlee, if you could give me the share screen so I can. We're going to be listening to some audio from these court hearings as well. So I'm going to talk for around 20 minutes. Sam and I have been tracking these Title IX lawsuits filed by accused students since 2011, when the Obama administration changed the federal policy. There have been, as of now, 591 lawsuits filed by accused students since 2011. And all of us sort of knew that at some point we were going to have a year with a significant number of appellate decisions that might shift the law in one direction or another. The question was, when would that year come? And it turns out that that year has come this year, in 2020. There have been 7 appellate decisions thus far, 4 favorable to the accused students, 3 favorable to universities. A couple more decisions are likely, at least in the next few months. So I'm going to be talking about some of those. But before doing so, we need to take a step back, because it turns out that basically every significant appellate case in this area, hovering over it, has been this 2019 decision from the 7th Circuit, ironically authored by Judge Barrett, one of her most significant rulings, and so the timing for this panel could not have been more appropriate. The Purdue case was one in which the procedures were atypically unfair. This was a case where the allegation was filed after a bad breakup between accuser and accused. The accused student wound up not merely being suspended as a result of this, but losing a ROTC scholarship and the possibility of a career in the Navy. This was after a hearing in which the accuser did not appear, much less subject herself for questioning. based on an investigative report which the accused student was never shown by Purdue administrators, and then perhaps the most remarkable thing, based off a statement that the accuser herself did not write. Instead, it was written by a campus victims' rights organization called CARE, which had some concerns about gender bias as well. And so we're going to start by listening to a clip with Judge Barrett questioning Purdue's lawyer, who seems to be not terribly eager to provide specific information about what Purdue did in this case. And to me, really the most impressive aspect of this clip, which is going to run for around 2 minutes, is the degree of preparation that Judge Barrett took. When the Purdue lawyer tries to evade, she's able to constantly get back into the facts of what was a quite factually dense complaint to sort of pin the attorney down.
Bingo.
Counsel, let me ask you another Title IX and 12b6 question here. So you say that he couldn't have satisfied Iqbal's pleading standard because he hasn't introduced evidence of bias. What about the fact that CARE touted this Washington Post article that said, alcohol is not the cause of a sexual assault, men are, and that then it was the director of CARE who prepared the very statement that summarized Jane Doe's allegations against him? Wouldn't that be sufficient to survive a motion to dismiss when you're looking for evidence of bias?
The director of CARE is not named as a defendant, and the director of CARE was not a decision maker in this process.
She doesn't have to be named as a defendant. The point is that it's some evidence of bias in the process, that's what Purdue relied upon to discipline.
But CARE is not a participant in the process as a decision maker. CARE is a resource center for people who report that they're...
Did CARE draft the statement of the victim?
Yes, in the same sense that Mr.
That's all I wanted to know.
So John Doe himself had a lawyer who participated on his behalf too.
Counsel, but I'm asking you about the evidence of bias. If in Iqbal had evidence that the Department of Justice or some entity within the Department of Justice had said something like, violence isn't the cause of terrorism, Muslims are. Mm-hmm. That might have been a different case about whether he could have satisfied his burden of stating a claim, right?
That would be a different case, but I don't think that case maps up well to this case. So the campus is a free speech environment. Different voices have spoken loudly on this topic, and part of Sexual Assault Awareness Month is for those voices to be heard. So hosting a forum where a Washington Post speaker voices an opinion does not make that opinion the view of the administration any more than any other.
Didn't CARE post this on its Facebook page? And it was a newspaper article?
It's a newspaper article by somebody outside of Purdue University.
That CARE posted on its Facebook page.
There's no suggestion that...
I'm not saying that CARE doesn't have free speech rights, counsel, but what I'm saying is that he has alleged in his complaint that CARE said something that might raise an allegation of bias when CARE and its director prepared the victim's statement on which the committee relied.
This went on for more than 20 minutes, and the lawyer's strategy here was peculiar to me because he rather than simply answer the question, he invaded and sort of got things in sort of worse condition. So it was clear after oral argument that it was very likely that Purdue was going to lose. They lost on both due process and Title IX, and it turns out that this decision, although it was very interesting on due process grounds, was more significant on grounds of Title IX. And here's what Judge Barrett wrote in this case. The critical quote is the one that I have here in dark red. Until the Purdue decision, the custom in handling Title IX complaints, so these are cases where the accused student alleges that he was found guilty as a result, at least in part, of gender bias by his school, was to use a kind of complicated test that was devised by the Second Circuit in the 1990s that required courts either to find a female comparator, that is, a female accused of sexual assault who was treated more favorably than the accused, or to determine whether the accused might have been innocent and then look for gender bias elsewhere in the process. And so you could often get these absurd results where obviously innocent students would be found guilty, but courts would say, well, that's not evidence of gender bias, we have to look elsewhere. And what Judge Barrett did in this opinion was to say, we're just going to dispense with this entirely. We're going to go back to the text of the statute, which is a statute that prohibits discrimination on the basis of sex, and simply pool all of the facts of the case together and ask this straightforward question. Do the alleged facts, if true, raise a plausible inference that the university discriminated against the accused student on the basis of sex? This is it's a much simpler, it's a much clearer, and it turns out, I think, especially for wrongly accused students, it's a much more plaintiff-friendly standard. And as we'll see, it has revolutionized how other appellate courts have considered this issue in the past year. In fact, all four favorable decisions for accused students relied, in one case indirectly, and the other three cases directly, on the standard that was articulated by Judge Barrett here. So as we look forward to these hearings, hopefully, in coming days, it's a reminder that the person who is being proposed for a seat on the Supreme Court has probably done more to advance the legal cause of the rights of accused students than any other member of the federal judiciary. So what were these four key decisions from 2020? We're going to start with a topic, Bill mentioned it earlier, and a group that's familiar, I think, to most regular readers of legal insurrection, and that's Oberlin, which changed its policies regarding sexual assault after campus protests in 2014 and 2015 in a process that was overseen by then Title IX coordinator, now Dean, Meredith Raimondo. And those of you who are legal insurrection readers might recognize that name. She was a prominent player in the Gibson's Bakery case as well. And this video, we're going to be listening to her explaining her rationale for the new policy at Oberlin. It's a striking video in many ways. If you listen especially to the second part closely, there's almost an implicit that ranges on explicit presumption of guilt in the Raimondo approach.
For me, the question and the goal of these processes has to start with this. For a student who comes forward to make a report, a safe, supportive space for someone to ask, what are the harms that you experienced and how can we address them so you can continue your education? And for the student who is accused, the question is also important and needs to be met, I think, equally with respect and dignity. But my question for that student is, what, if anything, in your conduct are you willing to be accountable for, and how can you be responsible for the harm you've done to others if, in fact, that was the result of your conduct? Hearings are a tool or a technique for answering those big questions.
Now, of course, it's very hard to imagine how a wrongly accused student should be held accountable for anything. It's the nature of a wrongful accusation, and yet that doesn't seem to have percolated into Raimondo's mind at all. And this is the person who designs the new policy at Oberlin and oversees this case, which, as Bill mentioned, is sort of deemed John Doe 1. So this was a case that was, much like the Purdue case, a remarkably unfair one. In the end, the key aspect of the case was the decision by Oberlin to find the accused student guilty of having sex with an incapacitated student. That decision came even though the only evidence of incapacitation in the entire record was the accuser saying around 40 minutes into a 55-minute or so sexual encounter, "I am not sober now," a statement that didn't come close to meeting even Oberlin's definition of incapacitation. There were a variety of other procedural irregularities in this case as well. The accuser dramatically changed her story during the hearing, saying that this was a forcible rape. It was not, in fact, an incapacitation case. The panel ignored her new story and simply found the accused student guilty on the old story. And also the accused student's advisor, who was supposed to be advocating on his behalf, who had been appointed by Dean Raimondo, left the hearing in the middle of the process, and then a couple weeks later tweeted out a statement saying that he wanted to send a message to all survivors everywhere that he believed them. So this case went up to the Sixth Circuit. It was decided actually in Oberlin's favor at the district court level. At oral argument, one of the panel, Judge Ronald Gilman, who was a Clinton nominee, made clear that he was favorable to Oberlin. He had also been favorable to the University of Michigan in the other big Sixth Circuit case, a case called Doe versus Baum. So John Doe 1 was going to need both of the other judges, Judges Raymond Kethledge, who was a W. Bush nominee, and Chad Riedler, who was a Trump nominee. This turned out to be the critical exchange of the hearing. Judge Kethledge's performance in this oral argument was remarkable. I think maybe it's the single best oral argument performance of any judge in these issues since the case started. And he hammered home on what is to be a sort of critical point of why can't it be inferred when you have an instance where a student is clearly found wrongfully guilty. Why can't there at least be the possibility that this is caused by gender bias? And here's Kethledge's exchanges with Oberlin's attorney.
The allegations, the proof can suggest a degree of egregiousness that goes far beyond the showing necessary to the first prong. And when that marginal difference is great enough, that difference itself can be evidence of bias in the particular proceeding. I mean, what's so contrary to common sense about that? Why is that an unreasonable inference? It's just about inferences.
Well, it's about plausible pleading, Your Honor, and
why isn't it plausible?
That is more than simply an inference, and it's implausible because the question is, was this particular proceeding biased against this man? In this particular case.
Well, let me ask you a question. Incapacitation, the university standard, it says the individual cannot make an informed and rational decision to engage in sexual activity because, in other words, for this particular reason, they lack conscious knowledge of the nature of the act or they're physically helpless. Examples of that in this are they're asleep, unconscious, otherwise unaware that sexual activity is occurring. How is that standard met here?
This exchange previewed what became the key holding in Kethledge's opinion, which was issued in June, citing to Purdue. The key argument was that when a degree of doubt passes from articulable to grave, the merits of the decision itself, as a matter of common sense, can support an inference of sex bias. There had been a couple of district court opinions that had gone this far, but this is the most aggressive of any appellate decision. And even though the Sixth Circuit had adopted a different pleading standard on Title IX issues, borrowing from the Second Circuit, Kethledge in effect incorporates the Barrett standard for this new test of a student who is in effect absolutely innocent can claim gender bias simply on the basis of a wholly illogical finding by his school. This is, I suspect, an opinion that's going to be regularly cited in Sixth Circuit litigation from here on out, and it's a real due process tool for students who are at private colleges who don't have the constitutional protections of the due process clause. Now, again, the Sixth Circuit couldn't formally adopt the Barrett standard because it had adopted a different standard. So at the start of 2020, the only states to which this standard applied were the states here in yellow in the Seventh Circuit. But over the course of the summer of 2020, the Barrett standard extended to the Third Circuit in a decision called Doe versus the University of the Sciences, then to the Ninth Circuit in a decision called Schwake versus Arizona Board of Regents involving Arizona State University, and finally to the Eighth Circuit in a case called Doe versus the University of Arkansas. And that was a case that was in some ways rather similar to the Oberlin case. This too was a case where the accuser's story changed dramatically in the process. This was also an instance where the university was under heavy pressure to crack down on sexual assault from the Arkansas state legislature, but also, just incredibly, from campus protests organized by the accuser herself in the middle of the process. And Arkansas's response to all of this basically appears to have been to find the guy guilty, even though they really knew that he wasn't. But to give him a slap on the wrist punishment, and this was a rare case where they didn't expel, they just give him probation, but there's a scarlet letter on his transcript, and as a result he sues. He gets a really tough judge at district court. It goes up to the appellate court, and you can get a sense of how this court in the Eighth Circuit, this was the first case that they've decided on an accused student Title IX case, was thinking about these issues in this exchange between Judges Stephen Colleton, who wound up writing the opinion, and Ralph Erickson, a Trump nominee who was very strong in this oral argument, and the University of Arkansas's lawyer.
Well, the complaints were that they were biased against female complainants, and so why wouldn't it be plausible that they'll say, well, we're going to have to find more men responsible, and maybe we'll go light on the punishment in order to kind of smooth things over.
I mean,
why isn't that plausible?
About the pattern of discrimination that they've alleged, I mean, first, their allegation says nothing about the evidence in those other cases. I mean, for all we know, I mean, the evidence...
Well, we don't have any evidence, that's true. But maybe that's why it should go to the development of the evidence. What about that?
No, Your Honor, because they have to state a claim before the doors are open to discovery. And number two, this allegation that they're making about this pattern of discrimination in other cases, it asks the court, they're asking the court not only to second guess the panel's decision in this case, they're also asking the court to second guess the panel's decisions in those other cases that they say establishes a pattern of discrimination. So
are they really asking us to do that, or are they asking us to say that there's a maelstrom of public opinion that's out there?
And that exchange becomes the basis of the decision. Again, incorporating the Barrett test, the Eighth Circuit holds that in this case, the courts need to look at the likely evidence of the accused in combination with a minor procedural irregularity and a general pattern of public pressure to come down hard on accused students. This is a pretty favorable pleading standard in Title IX cases, and it's remarkable the degree to which these other appeals courts, even though they're not in the Seventh Circuit, have found Barrett's reasoning on these issues of such high quality that they've chosen to adopt her standard regardless. Now, these are all Title IX cases. Pre-2019, in 2017, 2018, even 2019, the key appellate cases had tended to be due process, often with regards to hearings. There wasn't much of that this year, although there was this one important case, Doe versus the University of the Sciences, in which the Third Circuit interpreted a state law in Pennsylvania, which said that in fair proceedings, there needs to be some form of hearing. And the U of Sciences used what's called a single investigator model, which is a system in which a single person serves as investigator, fact finder, judge, and executioner, making all of the decisions. And the panel held, and en banc review was subsequently denied, that private colleges and universities in Pennsylvania must provide to accused students a hearing in some kind of adversarial approach. This is part of a broader debate. Some courts have interpreted fairness as applying to give a student a hearing. Other courts have chosen not to take that approach. The U Sciences decision is by far the highest profile, that has basically said if a university wants to promise a fair proceeding, it has to actually deliver it. Now, all that said, there have been three decisions that have been unfavorable to the accused this year, and I'm just going to talk about them very briefly. These two decisions that I have up here, one was in the Sixth Circuit involving a student at Case Western Reserve who admitted to the offense and then tried to say that the university wrongly found him guilty. Not an easy thing to do. And he unsurprisingly lost. And then this weird case out of the University of St. Thomas in the Eighth Circuit, in which the Eighth Circuit rejected the reasoning of a district court in District of Minnesota that argued that Minnesota state law under negligence theory required private universities to provide the equivalent of due process rights. The panel said no. These decisions are narrow and I think are unlikely to be important. The one final decision with which I'll close is a major decision, and this is the one big decision in favor of universities this year at the appellate level in 2020. This case is called Doe versus the University of Denver. And this is really sort of the anti-Barrett approach, basically saying what we're going to do is analyze not everything together, but every piece of evidence side by side. This was a case where the court concluded that Denver's conduct here looks more like a railroading, an extraordinary line, but said that this isn't gender bias, it's just anti-respondent bias, and therefore doesn't give rise to an inference of gender bias under Title IX, even though in the relevant process at play in the Denver lawsuit, every single accused student was a male. The 10th Circuit opinion, fortunately, right now remains an outlier. More circuits have taken the 7th Circuit Barrett approach, and I think this Oberlin decision is a particularly promising one that might provide a template elsewhere. Now, all of this is occurring outside of the concept of the new federal regulations. All of these lawsuits deal with adjudications that predated 814. And so Sam is going to be talking about the regulations side of things. Thank you very much.
Right. And now Miss Samantha Harris.
Okay, hi everyone. So yeah, I want to get into a little bit about the regulations. I'm not going to spend too much time, but I want to give you an overview of the due process provisions, because that's really, I mean, there are a lot of pieces, but that's, you know, I think obviously our topic here today is due process, and as someone who works in this field, this is the part of it that I think is going to be most significant. So, you know, these regulations are the most significant development in years, I think, on the Title IX front. And, you know, these due process protections are something that due process advocates have been fighting for ever since 2011, when the previous administration's guidance and aggressive over-enforcement ushered in an era of really campus kangaroo courts, where students were found responsible routinely for what are essentially, as Bill said, you know, serious crimes with no meaningful ability to defend themselves. So the new Title IX regulations include a number of important procedural protections. And as I said, they cover a lot of ground beyond just these procedural issues. They restore a definition of free speech, of sexual harassment that does not infringe on free speech, for example. And they ensure that victims, even those who don't want to file a formal complaint, will have access to supportive measures. But in the limited time I have, I want to focus, as I said, on these due process procedural protections, because as a due process advocate, that's really the biggest feature of these regulations to me. So first, the regulations require meaningful notice in advance of a first meeting, including the identity of the parties, the date and location of the events in question, and a description of the conduct that allegedly violated university policy. And believe it or not, and I know there are some people watching tonight who absolutely believe it because they've lived through it, many universities do not provide that on their own. We regularly see students and faculty called into meetings knowing nothing more than that someone has accused them of violating a campus sexual misconduct policy. That's deeply unfair, and there's really no justification for it, but it happens all the time. I have a client right now who was denied that kind of notice, and it's infuriating. This is the professor who Bill Jacobson mentioned at the beginning, and you know, I can tell you this because this is all the stuff I've written about publicly. So all of this is in the public record, and I know my client is comfortable with me sharing it. You know, I could spend a whole speech on the infuriating aspects of this case, starting with the fact that the harassment investigation against my client is actually just a pretextual investigation that the university launched because it couldn't fire him for some tweets about race and identity politics that made people angry. But for the moment, I want to focus on this notice piece because this is a really, you know, incredible example of what universities will do here. So after this professor's tweets led to protests and calls for his firing, the university president issued what was basically a public call for complaints put up on the university website about his classroom teaching, saying, you know, we can't fight. The president of the university pretty much explicitly told the local newspaper that, well, we can't fire him for his tweets. The Constitution prevents us from doing that. That's the law. There was almost like a hint of disappointment in his statement about that. So instead, what he did is he went online and said, if anybody's experienced any bias or discrimination in this professor's classroom, let us know. You can even do it anonymously. And so even though this professor had been teaching for more than 20 years with really little to no issues, even though his courses covered very controversial topics, suddenly hundreds of allegations poured in, if not thousands. And the notice of investigation that he received, though, only included a representative sample, maybe a dozen or so of these hundreds of allegations, with no information about when they allegedly occurred, about who had complained. And when we pushed back for more detailed information, the university told us that the incidents allegedly occurred between 2005 and 2020. So, that was really helpful. So instead of being given notice, my client was ambushed with hundreds of allegations in an interrogation that lasted 9 hours. And he's a faculty member. Imagine if you're an 18-year-old student, because this happens too, who simply gets a call or an email from your university administration saying, you need to come in, we need to talk to you about something important, or, we've received allegations that you may have violated the university's policy on sexual misconduct, and you have no idea what it's about. So under these new regulations, that kind of notice is insufficient. And that's, I think, a really significant due process protection. And it's something that over the years courts have held as an important piece of due process. The next important thing is that at colleges and universities, not in K-12, but in colleges and universities. Kemberlee, I don't know if you're seeing this. Somebody has put a question up here. Can you put me on full screen? We can see all four of you. I don't know if that's, I don't mind not being on full screen, but I wanted to make sure you'd seen that. So the next important thing is that at colleges and universities, the Title IX regulations require schools to provide a live hearing with the opportunity for cross-examination through the party's advisors. And this goes for both students and faculty. And this is one where it's really hard to overstate the significance of it. For years, many schools have been using a single investigator model, where instead of a hearing, you have an investigator who interviews the parties and witnesses and makes a decision without any kind of live proceeding where the parties appear together. It's really hard to challenge someone's credibility when there's no live proceeding. And this is something that goes for both parties, the complainant and the respondent. And it's something I've seen up close and personal since I started my own practice. When your client has the opportunity to address the panel directly, to hear from the other party, and to address inconsistencies in the other party's story, the process is much fairer. And so much so that it's really difficult for me to understand how in good faith people could oppose that. And the opportunity for cross-examination is also really important. And again, for both parties. If there are inconsistencies in one party's story, you need a way to be able to address those. And asking them through a third party like a hearing officer who can modify or exclude questions as they see fit is just not sufficient. The cross-examination requirement is one that has generated a lot of controversy and criticism because some people worry that it will re-traumatize victims of sexual misconduct and make them less likely to come forward. I was actually asked about this the other week. I had the opportunity to testify before Congress about these regulations. And I'll say now what I said then. Any process can be conducted sensitively or insensitively. A single investigator could be insensitive or even cruel to complainants or respondents, or could be thoughtful and ethical. And similarly, a hearing process with cross-examination could be conducted sensitively or insensitively. And it's incumbent on schools to ensure that any adjudication process is conducted with sensitivity. It's not like schools can't have rules about the conduct and deportment of advisors conducting cross-examination. And frankly, and I think Casey, because he knows all of these people too, will agree with me here, as one of the attorneys who does these types of cross-examination myself and knows many of the other attorneys in this relatively small group of people who specializes in this kind of work, I think this fear that these disciplinary proceedings are suddenly going to be filled with hostile attorneys who are grilling young complainants is just unfounded. I mean, everyone I know who does this work is incredibly sensitive to the complexities of these situations, and in fact would represent someone on either side of the coin of a complainant or a respondent, depending on where the unfairness in the procedure lay. The regulations also guarantee both parties access to all of the evidence that the university has gathered, and not just the evidence they intend to use in the proceeding. This is also critically important. Until the regulations, a lot of schools would give students access to just the investigative report or the investigator's summary of witness statements, rather than to all of the evidence and statements themselves. And when the parties can only review these summaries, they often don't get to see important evidence that might help them make their case. Sometimes universities simply don't think something is important or relevant. Other times they knowingly or recklessly leave out exculpatory or inculpatory evidence. And either way, allowing the parties to access all of the evidence greatly increases the fairness of the process. In a lot of ways, increased transparency is a theme throughout the regulations. We see this both in the provisions on notice and on access to evidence. We also see it in what universities have to say about, in what the regulations have to say about universities' training materials, which is something Casey has written a lot about, along with Stuart Taylor. Over the years, there have been many allegations made that the materials that universities use to train their Title IX investigators and hearing panelists are not appropriate training materials for individuals whose job it is to be neutral. So I'm talking about training materials that rely on stereotypes and generalizations, which is something that's wholly inappropriate for people whose job it is to judge only the case before them based on the evidence. So for example, if a jury that was impaneled to hear a murder trial were given a jury instruction that stated 99% of accused murderers are guilty, we would immediately understand that even if that statistic were true, it would be impermissibly prejudicial because the jury's only job is to decide whether there are facts proving that the accused individual in front of them is guilty. And yet universities' training materials would routinely include information about things like, the relative rarity of false rape allegations, which again may be true, but which says nothing about the individual case under consideration, and it could impermissibly bias an investigator or an adjudicator. So a number of the complaints brought against universities by accused students in court have made allegations about these biased training materials. But universities have kept these materials under a very tight lid. So the only way we know about some of them is through either litigation discovery or public records requests. But the new regulations require not only that universities not use materials that rely on generalizations and stereotypes, but it also requires that universities make these materials publicly available on their websites. And I think that transparency is important because I wouldn't trust universities not to continue using these materials if there were not some mechanism for people to actually confirm that they were doing so. So these are what I would say are the most important procedural protections in the new regulations. Now, if you or someone you love actually finds yourself embroiled in a campus disciplinary proceeding, you may or may not actually get all of these protections. First of all, the Department of Education has stated that the regulations apply only to allegations of misconduct that occurred after August 14th, 2020, which was the effective date. And the reality is that people often bring complaints about things that occurred months or even years earlier, which that could also be a whole other, talk. But at least for the next stretch, we're likely to continue to see a lot of disciplinary proceedings that are not governed by these regulations because the conduct in question occurred prior to August 14th. Second, I fear that schools are going to do their best to avoid the regulations whenever possible. In looking what a lot of schools have done with their policies after August 14th, many schools have adopted a two-track system where conduct that violates the Title IX policy may also still be tried under campus conduct policies too. So in other words, schools may be getting two bites at the same apple, one with procedural protections and one without. So I just want to talk sort of a little bit for my last couple of minutes here, more broadly about what goes on when you're involved in a campus disciplinary proceeding. Obviously, the focus of this discussion has been on campus sexual misconduct proceedings, but what I'm going to say is true of any non-academic proceeding where someone is facing suspension or expulsion. Particularly in this day and age, a lot of disciplinary proceedings are arising in the context of the racial and ethnic tensions occurring in the country. And both students and faculty are finding themselves facing disciplinary action simply for having engaged in protected speech on these topics that offended someone. And these allegations will typically be brought under a discriminatory harassment policy rather than the Title IX policy. That's governed by Title VI. And the Title IX regulations don't apply, so people facing those types of charges may not be entitled to many procedural protections. And because I may cut this a little short if I start running longer than I wanted, I want to summarize my sort of advice in 4 points, and then I'll go into a little more detail. One is, what happens if you or your child or someone you care about gets a campus conduct charge? First of all, get a lawyer who specializes in these kinds of things. Second of all, read the handbook and all of the policy documents from the university to know not only what your obligations are, but more importantly, what your rights are. 3, do not contact your accuser in any way. And 4, save everything. So let me ask Kemberlee and Bill, do I have a couple more minutes or should I be wrapping up now? I have a couple, okay. So one thing I always tell everyone is to read the handbook. And ideally, this should be part of the process of choosing a college or university. I often hear from distraught parents who say after the fact, when their child is being put through one of these kangaroo courts, how can the school do this? But unfortunately, it's often right there in the handbook. And private schools in particular have a lot of discretion over what kind of rules and regulations they can have. Public schools are at least bound by the due process clause, but at private schools, the issue is primarily contractual. So if a school followed its own policies, there's often little that can be done, even if those policies are unfair. But also, it's really important to read the handbook to know what your rights are, because schools won't always tell you. So for example, schools almost always allow students to be accompanied by an advisor, including an attorney, in sexual misconduct cases. Including an attorney. And in sexual misconduct cases, they're actually required by law called the Violence Against Women Act, to allow people to be accompanied by an advisor. But that doesn't mean that schools will inform students of their right to an advisor. So sometimes a student will have that right but won't know, and a student trying to represent him or herself in one of these proceedings can really have a disastrous outcome. Which brings me to my next point, which is that the first thing someone should do when they get notice of an investigation from their university is to contact an attorney who specializes in this area of the law. Now, I realize this probably sounds a little bit self-serving coming from an attorney who specializes in this area of the law, but it really is true, and you don't have to call me. There are lots of good people out there who Casey and I can tell you about. And really, the whole reason that I decided I wanted to start this practice is because in my role at FIRE, I would constantly be encountering these students and faculty in trouble. And what I was always saying to them was, you need to get a lawyer who can serve as your advisor. You really do need a lawyer as your advisor in these types of cases. One of the biggest mistakes students and faculty make, and I see this especially with faculty because they may have, a lengthy history of collegial relationships with their administration, is to assume that if they've done nothing wrong, things can easily get sorted out. But in this climate, that simply isn't the case. There are often much bigger things at stake for the university, maybe a perception that they're not tough enough on sexual assault or not tough enough on racism, for example, and they'll have no hesitation to throw innocent people under the bus to avoid bad publicity or disruptive protests or what have you. So it's important not to fall into the trap of thinking it isn't a big deal if you didn't do anything wrong. And on a related note, you have to be very careful not to contact your accuser. So first of all, anything you say, even if it's very well intentioned, could later be used against you. So for example, a lot of campus sexual misconduct cases that I deal with stem from, sexual miscommunications or failures to communicate in which one person genuinely believes the encounter was consensual and the other person genuinely feels they've been wronged. Now, this is not to say that there is not, real sexual assaults happening on campus, and there are, but, a lot of the cases where the students come to me, desperate for help are these cases where there's been some sort of, awful miscommunication. So often what happens in these cases is that when somebody finds out that they've been accused by someone they may have cared about, they'll reach out apologetically and send a text message saying, "Oh, I'm so sorry if I hurt you," not because they believe the encounter wasn't consensual, but just because they feel badly as a human being, knowing that someone they care about is hurt. And then time and again, we see these apology texts used to absolutely excoriate and hang the students who sent them. So as much as it might go against human nature, you simply can't send them. But also, very often, a no contact order is put into place almost immediately after a complaint is filed. So if an accused student isn't yet aware of this NCO, and this is something we see happen pretty frequently too, the student may not have checked their email yet and gotten the no contact order, and they may reach out to the accuser, again, maybe to apologize or what have you. That may actually be a violation of the no contact order that could get the student in further trouble. Plus, any remotely negative communications from an accused student may be viewed by the university as retaliation against someone for bringing a claim. So for all of these reasons, you simply don't want to contact someone who has accused you, no matter how painful or confusing that accusation may be. And finally, you want to preserve everything. Social media posts, emails, texts, Snapchats, screenshots, take screenshots, particularly with the popularity. I think apps like Snapchat are the bane of every campus disciplinary lawyer's existence, because in every case, so much potentially exonerating evidence is lost, and it's super frustrating. I have a case right now where my client and his accuser had a Snapchat conversation the day after the incident in question that could potentially exonerate my client, except it's totally gone, nothing. And, my client, it was an alcohol case, so, he doesn't have a lot of memory of the night, but there's this Snapchat that he remembers very well what it said, but we don't have it. And under certain circumstances, there may be ways to recover some of these things using a digital forensic specialist, but that's expensive and uncertain. So honestly, the climate being what it is, in my ideal world, people simply wouldn't have these types of communications in ways that couldn't be saved, but that's not realistic. So at the very least, from the first moment you get a sense that anything is wrong, whether it's, hearing rumors or anything like that, you got to start saving. So that's kind of my little spiel on, what to do if it happens to you. I think I have probably used up all of my time and then some, and I see we've already got some questions. So why don't I be quiet now, and we'll if people want to stick around, I'm happy to stick around and take questions.
Well, I have a question, which is, I think it's certainly good advice to get a lawyer, but I think a lot of people are going to have financial issues with that. And it's not as easy as it might seem when you're being asked to make a decision, maybe on minutes or hours notice. You've been called down to the dean's office, to the investigator's office. You don't have the time. What do you suggest that a student does when called down to an investigator's office and they're ambushed? Do they get up and walk out and say, "You'll hear from my lawyer"? Do they answer questions? Obviously none of this is legal advice for any specific situation, but what's your advice in that sort of situation as a general matter?
Right. Yeah. And it is a tough, the financial aspect is really, really challenging. And just sort of as a broad thing, I really think that there should be some kind of legal defense. I wish that some kind of legal defense fund existed for students and faculty in these situations. But, if you are, it seems like what you're asking is, okay, if you have to go into one of these things unrepresented on your own, what should you do? First of all, even if you cannot bring a lawyer as your advisor, you can bring, the advisor can be a lawyer, but it doesn't have to be a lawyer. So you should bring someone with you to bear witness to what's happening, to take notes, just to be in the room with you or on Zoom with you. It doesn't, if you can't get a lawyer, if maybe it's your friend, maybe it's your mom, someone who can bear witness and can take notes. Second of all, I always tell my clients that if they're asked questions that they're not prepared to answer, to say, listen, I wasn't, this is the first I'm hearing of this accusation. In order to defend myself, I really need to know a little bit more about this. So, can you tell me now, and we can schedule a time to follow up? I mean, typically, if I have a client who gets that kind of meaningless notice, hey, you need to come in for a meeting, I will have the client write back and say, could you please tell me a bit about what this is about? What I'm accused of doing, when. Oftentimes the school won't comply. So if you do have to go into a meeting that's going to be an ambush, I would not. I mean, sometimes, it does depend on the situation. I've had faculty who do feel comfortable answering questions on the spot. But really, you should not, if you feel unprepared to answer the questions, I always think it's worth saying, and you have to really kind of use the language, and this is why reading the handbook is important, because you want to use the language of your rights. Listen, in order for me to meaningfully defend myself here, I need to, I need to have some notice of what happened and some time to prepare. So, tell me what's going on, and then let's schedule a time to follow up. So that would be sort of my advice for those initial meetings, but always have someone there to bear witness to what's happening. Don't go completely alone, even if you can't bring an attorney.
Thank you. We get that question a lot, so I really appreciate you taking the time to answer that.
Oh, and I should say that while FIRE, I am a senior fellow at FIRE, and I also have a private practice. But what I did a lot at FIRE that sort of drove me into private practice, because I really wanted to be able to do more sort of hands-on to help students. But, FIRE has resources for students who need to defend themselves. They have like a little sheet they can give you. You can talk to someone there. And there's there's a firm, Kaiser Dillon, which is one of the top firms in the country that represents these kinds of accused students. They have a free downloadable guide on their website for your guide to defending yourself in a campus disciplinary proceeding. So there are resources out there, FIRE, the Kaiser Dillon guide. Those are things I would recommend, at least to get some. Obviously, ideally, you have an advisor who's a trained attorney, an attorney or who's otherwise trained in this. But if not, there are resources out there for, people who are going to have to defend themselves. And I would highly recommend that people try to connect with those resources and to prepare.
Great, thank you. This is just a general question, and it's one that speaks a little bit more, I guess, in broad terms, but it's one that we get quite a bit, and it's simply that how does it profit institutions of higher education, colleges, community colleges, any of these entities to dabble in due process as opposed to passing these accusations and these kinds of issues, which are pretty heavy and pretty serious, and in most cases would bear some kind of legal weight and responsibility were law enforcement involved? How does it profit them to get involved in this versus passing it off to law enforcement, and why did they choose to do this as opposed to passing it off to the entity that's equipped to handle this?
Well, I can take this one too, if it's okay. And that's sort of similar to the first question that I see up here in the Q&A too. So I think we can sort of knock these two questions out. The answer is that they didn't choose to. The answer is that Title IX requires schools to have grievance processes for addressing sex discrimination, and that through a series of court decisions and administrative guidance over the years, sexual harassment, including physical sexual misconduct, student-on-student sexual harassment, including physical sexual misconduct, is a form of, if a school is aware of it and does not take steps to remedy it, that can be a form of sex discrimination that the school is liable for. So Title IX requires schools to have grievance procedures for these things. Also, schools' definition of sexual misconduct is often very different from, what would be considered sexual misconduct at law. I mean, we could do a whole thing on the affirmative consent standard that campuses use versus, the sort of traditional legal consent definition used at law, but much of what's adjudicated as sexual misconduct on campus would not, in fact, be illegal. So that's another reason. Now, I'm not saying that I think that it's good that schools are doing it, but because of I would say, and I don't, Casey, maybe you feel differently, but I feel like because I get this question a lot, and because, we're talking about 30 plus years of court decisions and administrative guidance sort of establishing that under Title IX schools have to deal with these things, I think that's the reality of the situation, and that we have to focus our efforts on ensuring that those processes are as fair as possible.
Yeah, that's my sense as well. It's an interesting theoretical discussion, just philosophical discussion of should colleges and universities handle these or not. But in the real world, they've been required to do it for more than 20 years, and there's no conceivable academic environment in which we would go back to the system of the 1980s. And so we are where we are, and we have to deal with the realities of it.
Thank you. And this question comes from Gilbert, and Gilbert asks this. He says, college administrations continue to fight court rulings which have opinions as to the ruling. Where are the attorneys for these administrations that should advise them on their unsupportable positions and thus drop their opposition to court rulings? Anyone?
Yeah, this is, I think there are a couple of interesting things here. So the first is that universities, as Sam mentioned in her presentation, often have competing interests. And so dropping a case may make legal sense for an institution, but it may cause bureaucratic problems within the school itself. And so I'm thinking here of a school like the University of Michigan or the University of Cincinnati, both of which very aggressively pursued what were basically sure loser cases to the Sixth Circuit Court of Appeals, and wound up generating really good rulings for the accused students. The other factor here is that in a lot of these cases, it's not the general counsel's office that's representing the university in court. It's a firm that's hired by the university's insurance carriers. They may have their own interests in moving forward, and so even if the general counsel's office may have concerns, the lawyers may want to fight. All that said, in the cases that Sam and I track, there are almost 100 of these federal lawsuits that have been settled before any court decision in that case was filed. And it's true that a settlement by a university does not mean that they're admitting that they did anything wrong. On the other hand, the primary demand in almost all of these cases by accused students is they want expungement of their record. So these are cases where the university is making some kind of legal judgment where we may very well lose here. We can get rid of it easily, and so we are going to get rid of it easily. So it's not as if every university is the University of Michigan or Boston College. These schools that are notorious for just fighting, losing causes. Sometimes they do make what is the rational decision and settle.
And to kind of piggyback on that, it's a question that I have that I think kind of encompasses some of this as well. Do we see, or do y'all see in your extensive coverage of this, any increased liability for colleges that engage in these kinds of things? And the case that comes to mind is the mattress girl. And I believe it was at Columbia University where at least the defendant alleged that it was a consensual event. They continued communicating via Facebook Messenger after the fact. She later decided that she'd been taken advantage of and claimed that she'd been raped and went to the school. He claimed then after the fact, after going through the court or the school system, that he'd been defamed. and I believe filed suit against Columbia after the fact. Is that something that y'all are seeing any more of? And that case is several years old now, but is that something that y'all see often, or any uptake, or is that an outlier?
I mean, that's the only decision I'm aware of like that. I mean, that situation was a little bit unique in the sense that, I mean, there were posters plastered all over campus with his name, calling him a rapist. I mean, it was very public. And, the claim he brought was essentially similar to the claim that a lot of, female victims of sexual harassment bring, which is that the university allowed a hostile environment to exist for him and did not do anything about it. And I don't see that happening a lot. I think that it is a huge issue. The way that these students are treated by other students on campus can be a huge issue, and defamation can often be an issue. I have a case right now that I am quite certain includes a defamation component because, students at the school have posted a change.org petition online about my client, accusing him of things that are per se defamation. I mean, there are certain categories of things that are just, if you say them, they are defamation. If you accuse people of heinous crimes that they didn't commit, they are defamation. And the crimes he's being accused of in this petition are not even, I mean, the charges against him in the campus conduct system are relatively mild compared to the things that are being said online. Now, I think in those cases, people may need to start bringing defamation actions against the people who put up petitions like that and things of that nature. But as to the school's liability, that would have to come under a hostile environment theory. And that's tough because then you are getting into free speech issues too.
And maybe it's more of a defamation issue too, because I mean, inevitably, if someone is accused of rape, whether or not they're guilty, there are going to be social repercussions for that. And that's something that we've tracked quite a bit over the years via our college insurrection coverage.
Right. Now, of course, truth is an absolute defense to defamation charge. Right. So if the person actually did do it, that's a different story.
Right.
But of course, that raises, I mean, God, there's so much we could go into here. Okay, yeah, I see Jacob Bill has said we should try to get to as many pending questions as possible. Yes. So I will not go off on the tangent. I will not go off on the tangent I was about to go off on.
Okay, well, we'll move on to Erica's question. And Erica asks, do parents of sons getting ready to head to college in the next few years have any leverage to pressure colleges, universities to start handling these cases more fairly?
Well, I think it's like anything else, and we could talk about it in the free speech context or other things, that probably parents have very little leverage to get the schools to change, but parents have a lot of leverage in terms of the college to which they send their child and pay tuition. And I think that people should do their due diligence as much so as they would on what the dining hall serves and how many tennis courts there are, as what the campus culture is, what the campus policies are. And I think that since most of the accused are young men, wherever you send them, you need to have a talk with them about what they are stepping into and what they do if they get called down. I mean, we don't want to think our son would do such a thing, but they may find themselves in a situation. So I think parents have the power of the parents is where they go. The administrations, I think, are oblivious to pressure because, as I said, this is a political cause for many of them. It's a quasi-religious cause for the administrations. And I think changing them or convincing them to change is remote.
Yeah, and this is from an anonymous attendee. It's pretty specific, so I'm gonna leave this to probably Sam and Casey. Any new court cases decided or pending in Pennsylvania after the California 3 decision on University of the Sciences case that Casey mentioned? Also, how does the California 3 decision work in the context of new regulations?
Yeah, there have been two decisions, one favorable, one unfavorable. The unfavorable one was a decision in a lawsuit against Drexel College. where Drexel University, where the student did not, the university did not provide a real hearing. And the court in that case, it was an Obama-nominated judge, defined the University of Sciences ruling very, very narrowly. If you remember from the slide, the text of the ruling says the requirement is for a live and an adversarial hearing. And Drexel provided something approximating a live hearing, but not adversarial at all. And the court sort of pretended that argument didn't exist. So that and the university therefore won. The flip side of this, there's a lawsuit ongoing against the University of Delaware, and both due process and Title IX. And very interestingly, in the Delaware case, the university withdrew its motion to dismiss on the due process count. The student alleged that Delaware used a single investigator model, didn't give him a hearing, there was no cross-examination. And the university's decision, which they explained in the hearing in the case, was that, well, since the Third Circuit has said that private colleges and universities under a fairness doctrine have to provide a live and adversarial hearing, that surely means that the Third Circuit would apply that right to public universities as well. So for the Delaware student, this has been a good thing. For the Drexel student, it didn't work out, which is a reminder. I saw the other day on Twitter, Kathy Young, who does just sensational work on this issue, and she pointed out, well, it is good in a lot of ways that we have some of these positive court decisions, and it absolutely is. But at the end of the day, even in the best of these lawsuits, it often comes down to the draw. Which judge is the lawsuit ultimately assigned to? And so going to court always has to be a last resort to get justice. It's very expensive. It takes a long time, and you're not guaranteed a victory even in the strongest of cases.
I will add just very quickly, because I practice in Pennsylvania, which is in the Third Circuit, so this decision applies here. And it has had the University of the Sciences decision, which, just recapping really quickly what Casey described about the decision, it held that, if a university contractually promises fairness, that requirement in this context includes the right to a live hearing with the So, I have a case, for example, at a college in Pennsylvania that was going to use a single investigator model in my client's case. And after the University of the Sciences decision wrote down, and this was part of the question that was up, was how does this sort of interplay with the new regulations? And in a lot of ways, what it does is it gives students in Pennsylvania and other Third Circuit, which is PA, New Jersey, and Delaware, gives students at Third Circuit colleges and universities the protections of the regulations in a much more straightforward and immediate way, because I was able to cite this decision right away and say my client needs a hearing, and they're giving us a hearing. So, the decision had an immediate and positive impact on fairness in these types of proceedings in schools in the Third Circuit. I see this next question, which I can address, I think, pretty quickly. In a professor bias charge against him, can he rely on a faculty union representative? The answer is that if the faculty is unionized, you can have a union representative. In my experience, when it comes to the union grievance processes, typically pick up once someone has actually been disciplined. So in terms of what you can get from a union in the investigative process, I mean, in the case I've handled that had a situation like this, what the faculty member would have been entitled to in the investigative process was a non-attorney representative who would have essentially gone and just sort of been a silent witness, which is better than nothing. I mean, if you can't get outside counsel, like I said, you want someone to bear witness. But in terms of somebody who is going to sort of advocate for the faculty member at the investigative stage, my experience, which is not super comprehensive, so take that for what it's worth, but my experience is that at the investigative stage, rather than the stage once you've actually been disciplined, that you may not get a ton from a union. So that's just That's my 2 cents.
And it's worth tossing in my 2 cents as someone who was experienced as someone who went through this during my tenure process. Very often the faculty unions are themselves compromised, that they may be ideologically sympathetic to the administration or to other faculty who are out to get you. And so in my experience with faculty unions is, I hired a lawyer almost immediately. In my tenure case, it was the best thing that I did. And, going back to the original advice that Sam offered, anytime, whenever I hear from an accused student or an accused professor, that's the first piece of advice I give is you have to get a lawyer.
One of the points I made, and it's very important that people understand this, during our cancel culture event about a month ago, is there is a misconception, which is in many ways perpetuated or perpetrated by universities themselves, that because they are in the education business, they are somehow nicer and kinder than other businesses. And I think, if anything, the opposite is true. I think there is probably more sympathy for the accused at chemical companies than at universities. We've seen this. KC has chronicled these cases. Samantha fights them. I've reported on them. The universities are simply large corporations, in most cases multi-billion-dollar corporations, who happen to be in the business of higher education. But they fight these things. They are every bit as brutal and vicious as any other big business in protecting their financial interests and whatever else their interests are. So I think there's a misconception. I think a lot of students have it because there's a dean of students, somebody who's there to help you. Well, the dean of students is not there to help you. And I don't mean this in a personal way to a specific person. As a category, they are the equivalent for students as the human resources department in a big corporation. Human resources department's role is not to help the employee, except perhaps in ministerial things like filling out your IRA form or something. But they are there to protect the corporation. And they are there to protect and to gather evidence against you should you bring an employment claim. And the infrastructure at universities, that's the rough equivalent. The dean of students, various advisory administrators they have, are not there to help an accused student. They are there to protect the university. And I think people need to understand that.
The next question is a technical question. It's from William, and William asks, does the hearing have to be recorded? It's a great question. I'm assuming that would mean, I'm taking that to mean a hearing if it's an initial hearing that you're meeting. Let's say you've been accused of something, you go in to meet with something. Should that be required, or should it be recorded, or does it have to be recorded?
I don't know that it has to be. I mean, I think most schools, that's specified in most schools' policies, whether or not it will be recorded. I don't know, Casey, do you?
Under the regulations, they're supposed to be recording the adjudication hearings, but an individual meeting with, like Sam was talking about, when you get the notice and they call you quickly in, those generally are not recorded, although I have encountered cases where they have. And here, again, if people get nothing else from this session, it is that you need to look at the handbook of the university to figure out that right will or will not be spelled out by the university.
Oh, yes. And I should also add here in terms of things you need to look at, because this is something that students do sometimes, and I understand it, but you can't go into a meeting and record it yourself without being very certain if you're in a one-party or a two-party consent state, because in two-party consent states, it is illegal to record without the other party's consent. So you can't just go in and turn your phone on and record a meeting. As much as I totally understand the impulse, because if you think you're about to be railroaded, you're going to want to get a record of that. If you're in a two-party consent state, you have to ask permission to record, otherwise you can't record. This
question comes from H. Heasley, and They ask, do any of the panelists think that at some point in the future there's a possibility of class action lawsuits against universities or the Department of Education using due process or gender bias as a basis for the complaints?
So I think the answer to that question is likely no. There have been 2 class action lawsuits that were filed, one against Michigan State in federal court, one against the Cal State system in California State Court. And both of those were dismissed for identical reasons by the courts, which was that there really is no certifiable class here. Is the class wrongly accused students? Is the class, all charged students? Because even the broadest of these rulings on the due process grounds, which is the Sixth Circuit opinion in Doe versus Baum, makes clear that a right to a hearing and a right to a cross-examination applies in cases where credibility is on the line. Federal courts essentially uniformly in the campus disciplinary process have said that in cases where the accused student is independently guilty, so let's say that the accused student has pled guilty to a crime in criminal court, or that's a Sixth Circuit case, or there's video of the accused student assaulting the victim. That's a Fifth Circuit case. They've said there is no right to a hearing and cross-examination under those circumstances. So in both of those cases, both the class action attempts that I was describing, the courts kicked them right at the start by saying, there isn't a certifiable class here. So my guess is probably no.
We're going to take 2 more questions, and but before we do that, there's a question that we get pretty frequently, not only on the blog, but I know in our email inboxes for readers who are curious about this. And it's speaking to where parents can go to find out which schools are the best on these issues. Because if you're going to be spending a gazillion dollars to send your kids to college, you would rather put them in a place that's going to be the least hostile environment and still provide a best book education. So given that y'all do this, can you provide us some pointers there?
Well, so FIRE does rate, they take the top 50 schools, well, it's actually 53 because there are some ties, but like US News top 53 schools, and evaluate their policies, both in terms of sexual misconduct and non-sexual misconduct. Because again, like those cases come up a lot too, and you're right there. We don't have the new regulations in that context. And if you're charged with hazing or you're charged with racial harassment or any of these other things, you're still going to have to deal with a totally different disciplinary process that may not provide a lot of procedural protections. So there's some information about that on FIRE's site about the top 53 schools. Another thing I would say is I have to be honest, this is an issue where it matters whether you're at a public or a private university, because you do have some due process rights at a public university, whereas at a private university, you don't. That said, look, Casey and I could both say, and I don't want to, call out any particular, specific schools, but if you want to call me privately, I'd be happy to call out particular schools. I mean, when you look at the lawsuits, there are some schools that just come up again and again and again as repeat offenders. There really are some extremely bad actors that just care nothing about students' rights. So I would say, look at Casey and I publicize the list of lawsuits and take a look at the suits, and if a school has been sued more than 4 or 5 times, that might be a red flag. But other than that, I would say again, like, read the handbook, make that part of your choice process.
Thank you. This question is also from an anonymous attendee, and they ask, because of the very different decisions in California 7 for Purdue and California 10, Denver, how likely will a case on this topic, Title IX, end up being in the Supreme Court anytime soon?
Casey, you want to take that one?
Well, it's a tough question. One of the weird things about this area is that even though we're dealing with similar issues and there are clear circuit splits, so between like Purdue and Denver on the appropriate standard for Title IX, the First Circuit and the Sixth Circuit disagree on whether there's cross-examination. So in theory, you could say, all right, we're going to move forward. All of these cases have all of the decisions are factually dependent in some way on the cases, and so there's enough distinction between the cases. There have been only 2 cases by accused students that did file cert petitions for the court. Both were horrible cases where the students they just had no chance of winning, and the court denied cert. In theory, you would think eventually this is going to find its way to the Supreme Court, but there's no guarantee. From the accused student standpoint, what Sam mentioned earlier, there's no legal defense fund. So unless you have a really, really wealthy defendant, going on your own to the court is hard. From universities, I do think in some of these really weak cases, universities may be hesitant to file appeals. Even the University of Michigan, Sam didn't want to call out anyone, I'll call out at least one university, was smart enough not to seek Supreme Court review of Doe versus Baum, which could have constitutionalized a right to a hearing and cross-examination everywhere.
This last question is from Deborah. And Deborah asks, is there a college process in place as a separate matter for Title VI, which is a racial issue? So much recently has been so broad it might not be considered racial, yet seem to be treated as such. The example I think of is the flag installation for 9/11 at Baylor, which had a trigger warning tag as well as identification of the sponsor of the installation, which caused substantial pushback to the campus alleging racism and the installation sponsor, as well as filings to remove the group from campus. Those allegations followed the disapproved of installation of flags. I know this is more abstract. It involves defaming a group of people and not a single person.
Well, so, the Department of Education has not, regulated disciplinary procedures in the area of Title VI the way it has in the area of Title IX. This is actually a topic that I am sort of planning an article on in the next few months, because I think we might, particularly under a Biden administration, I think we might see a push to, have the equivalent of a 2011 Dear Colleague letter, but in the Title VI context. But typically, colleges have Title VI harassment is governed by discriminatory harassment policies. Generally speaking, those adjudication procedures you're usually adjudicated under a school's general student code of conduct procedures, which, now it's funny because, prior to the new regulations, oftentimes those conduct codes provided more procedural protections than the sexual misconduct procedures. Now I suspect they will typically provide fewer. And that's why I've sort of been talking about some of these broader issues, throughout the course of this presentation, because there are going to be a lot of campus disciplinary issues that arise, I think particularly in this racial harassment context now, given the current climate, where, the protections of the new regulations are not going to apply. So all of the sort of issues of needing to be hyper aware of your school's policies and your due process rights and all of that are going to be extremely critical.
Thank you. And just as kind of a final round robin before we wrap up, we did include in the title, we said that we were going to discuss what's next. So just a brief prognostication on what this looks like post-election, depending on who wins. I think we have an idea based on what's transpired through Trump's first term, what we might see moving forward. And I think now that we're getting more information on who Team Biden has tapped for their transition team and who they're eyeing for particular administrative posts, what that might look like moving forward. And so I'm going to pass that one to Professor Jacobson to start with.
Well, I think that if there is a Biden administration, it is going to be back to the Obama days, back to the Dear Colleague letter, back to almost an extreme pressure on colleges to err on the side of finding people guilty. And I think that, as it's going to be in many other fields, It will simply be even more ideologically driven, less emphasis on evidence and reaching a fair and just result, and more on reaching a result that serves a political purpose, which is how we got into this mess to begin with.
Yeah, I would say sort of two things with regards to a Biden administration, which looks likely beyond what Bill pointed out. The first is, I mean, we've been talking a lot about these court decisions, and it's an overgeneralization, but it's an overgeneralization that's worth offering. At the appellate level, Trump-nominated judges have been better than W. Bush-nominated judges, who in turn have been better than Clinton-nominated judges, who in turn have been much better than Obama-nominated judges on this issue. That's not to say there haven't been a couple of good Obama-nominated judges, which there were, and that there's been a couple of bad Trump-nominated judges, which there were. I suspect if we were all to come back here 4 years from now, the Biden-nominated judges will be much, much worse on this issue than the Obama-nominated judges, because this is an issue that, unlike Obama, frankly, Biden seems to care passionately about. I mean, he is deeply committed personally to the cause of eviscerating, due process rights for accused students. And secondly, at the federal level, this litigation didn't start to proliferate until 2014 or 2015, so it was never a litmus test for judicial nominations during the Obama years. I strongly suspect it will be a litmus test, at least at the appellate level, for judicial nominations during the Biden years.
Do you have anything to add, Samantha?
No, I don't think so. I don't think so.
Okay.
That was pretty comprehensive.
Okay. Well, with that, I want to thank you so much for joining us this evening and for spending your Sunday evening with us. I think it's very central to what we do at the Legal Insurrection Foundation is to fight back against these things, to fight back against due process grievances and missteps, no matter where that's happening, in any way that we can. And to remind you too that you are not alone in this. I know that the world is a very scary place right now, culturally, politically, in just about every single way. Diseases, all of that, but just know that you are not alone. We are always a resource for you. We can't provide legal advice, but we can at least point you in the right direction. And we want to extend our just tremendous thanks to both Professor Johnson and to Samantha for taking time this evening to share their expertise and their knowledge on this subject with you. And again, thank you so much for joining us. You can always find us on legalinsurrection.com. And again, we are purely donor supported. So if you appreciated the content and if you learned tonight, please consider throwing a couple bucks our way so that we can continue doing this free for you and everybody else who might be interested. And tell your friends, have a watch party. It's a lot of fun. So thanks everyone. And we hope you have a wonderful evening and a great week ahead, and know that we're always here. Good night.
Thank you.
Bye-bye.